and also about the mechanics of a default order, default judgment. But before I ask you those questions, it struck me as unfortunate is too soft a term, that you were placed in this position where you were forced to resign. You receive a subpoena, you want to comply. I mean, in your own words, why did you feel compelled to resign?
Well, the law still governs this country, and there's a federal law that says that you all have the power to issue the subpoenas, and that federal agencies must comply. And I personally received a subpoena, and I've learned since I was in law school that when you're subpoenaed, you have to comply, or you go through the judicial process to extinguish the subpoena, which my attorney begged the department to do. Please file a motion to quash this subpoena. We will not oppose it. We'll be happy as a lark if that happens. There are some comical blogs that said that I was fighting to testify. That's not true.
Were you told that they would not enforce the subpoena?
Oh, yes. Oh, yeah, that was the reason that I need not comply, because they had no intention of enforcing it.
Let me turn to this culture question. You talked about this culture being open, pervasive, bordering on a policy in terms of the lack of neutral application of the law. And I understand this pertains to white victims. I understand this pertains to not prosecuting blacks that violate the law and seek to prevent others from voting or intimidate others. Did you hear a discussion of the refusal to protect black victims in this regard? Because one of the overlooked facts pertains to a poll watcher who was African American. And we had testimony from Chris Hill, who was a lawyer there on site in Philadelphia. And he talked about seeing the Black Panthers walking in to find the Republican poll watcher and finding an older African American cowered in the corner who told that there would be hell to pay if he stepped outside. Those same folks who refused to protect white victims, those same folks who refused to prosecute blacks, do they also refuse to protect black victims in that context?
Yeah. This also goes to the U.S. v. Ike Brown case. In Noxubee, we had black victims there. Individuals who got visits from notaries who cast their ballots for them, they denied them the right to vote as part of this illegal scheme to harvest votes. We had a witness at trial in Noxubee say she was harassed by the defendant, and she said, "Don't you dare come around here telling me how to vote here in Mississippi, how I ought to be voting." This is a black lady. How dare you in this place come and intimidate me into this? There were black victims over and over and over again in these cases. That's something that's lost on the civil rights groups who oppose these cases. It's tragic because it's the people they purportedly protect are being harmed and losing their right to vote.
Let me talk to you, if I could, for a moment, for my last few minutes, about the mechanics. We have our timeline here, and you all filed your complaint. They failed to respond, and our timeline indicates that a default order was entered. Now, that's not a default judgment. It's an order of default, correct?
That's right.
It's important that folks understand this difference, because a default judgment can require some type of proffer or discussion in open court. And going back to the Rule 11 question, as an officer of the court, you're required to be truthful and honest and forthright to the court, even in the context of an adversarial proceeding, even in an instance where the other side does not appear. You're still required to be truthful and honest in order to have a default judgment in most cases entered. Were you prepared if the judge had said to you, Mr. Adams, you're a member of the trial team, I assume, were you prepared to present evidence to the judge to support your request?
I think the answer is obvious. Yeah, but I don't want to give it. I will tell you that any plaintiff who brings this case will not have a very difficult time in a similar posture to present evidence.
Well, let me ask you a question another way, because you signed the initial complaint, as did Grace Young Becker, as did Mr. Coates, and Mr. Popper's name is on it as well. The allegations in the complaint, they are what they are. Had the court said to you, provide evidence to support the allegations in the complaint, you filed. Could you have done that?
Yeah, let me backtrack. I wasn't saying I wasn't going to answer the last question because I didn't know the answer. I was saying because I am afraid that it could tread on deliberative process. I assure you, based on my experience with the attorneys involved who are the best in the business, the best. Chris Coates is the best. Popper is brilliant. He's like a professor. I hope he comes here sometime. There is no doubt what we would have done if we had proceeded. We're good attorneys, and you prepare.
Thank you. Commissioner Harriet?
Well, first I want to say that I agree with Commissioner Christmas that what you're testifying to is quite extraordinary. And I think I'm going to resist.
Excuse me, Commissioner Harriet, do you have your mic on?
Do I? Well, no. I'm also going to resist the temptation to ask you about what the housing section has against picnics. But Commissioner Taylor started on a road that I'd like to at least touch on. I'm not sure whether this is going to be a question that you can answer or not. But as Commissioner Taylor has been saying, this case went into default. And it's certainly true that courts do not always simply enter judgment upon default. They require some proof. But Mr. Perez told Congress, I believe, that he put it in such a way that it made it sound like a default was actually an obstacle. Just for the record here, if you can tell us, it's a good thing, isn't it, for plaintiffs when the defendant goes into default, when the defendant fails to appear?
It's a beautiful thing.
It usually makes your job much, much easier.
The only thing that makes it easier than having a default is when there's actually video.
Gosh, was there video in this case?
Yeah, there was that too.
Yeah. I heard about that too. Well, let me go to some of the nuts and bolts here, and that is Mr. Jackson. Mr. Jackson, I am told, was actually a poll watcher himself, right? Certified, I guess, by the Democratic Party?
Mr. Jackson was indeed, he's not only a poll watcher, he's a Democratic Party elected official in the city of Philadelphia, the tall Black Panther. He's an executive committeeman in that particular precinct. He wasn't on the ballot that day, I should note, though.
Okay. The police, I believe, when they came and told Mr. Shabazz, the one with the Billy Club, that he had to vacate the premises, they let Mr. Jackson stay. Does the fact that Mr. Jackson was a poll watcher have any bearing on his liability?
No, thank heavens no. I mean, otherwise you would appoint as poll watchers the biggest and baddest thugs you have and give them credentials to roam about the community, nor does the fact that the police let him stay have anything to do with it. The federal government has never taken the position, and hopefully never will, that local law enforcement officials can opine on matters of federal law. We have entirely different laws that we enforce, and the Philadelphia police don't enforce federal voting rights statutes.
So you don't have to defer to the Philadelphia police?
Of course not.
Okay. Just want that for the record.
Yeah.
And I would think, if anything, the fact that Mr. Jackson was a poll watcher might even raise the standard of care we'd expect from him, wouldn't it?
Well, you know what? I don't want to add or subtract elements from the statute. It was so clear, the statute is what it is, and I don't think we need to add requirements. That's just my personal view.
Well, you think that he gets training, and therefore at least he knows things. It makes it more difficult for him to say, I didn't understand this.
Fair enough.
Okay. What about the, I'm skipping around here because my colleagues have already asked you a number of the questions that I wanted to ask you. But one issue that interested me was the ultimate injunction that was, well, first the injunction that was asked for, and then the rather severe reduction in that injunction. What was originally asked for?
Well, if you read the complaint, I believe it asks for an injunction against all the parties. I don't know whether it says nationwide in the complaint. I can't remember. But it clearly asks for an injunction against all the parties.